All right, I'm Jim Astrachan.
And I'm Donna Thomas.
And we're from Astrachan, Gunst, and Thomas in Baltimore, Maryland. Our website is agtlawyers.com. And we're here to talk about vulgar, disparaging, rude, and crude trademarks.
All right. So we've talked a little bit about what a trademark is. And now we're going to deal with a subset of trademarks. So why don't you give us some examples or an explanation of what a vulgar and a disparaging trademark is?
All right. Well, this may have to go X-rated, though. Is that okay?
That's okay.
All
as
right,
long as
then.
I'm not the one doing the presenting.
All right. So, and normally I get you to do this class in my trademark class at the law school.
And I'm miserable.
And you're miserable about this. But now it's my turn to be miserable on film. So there were two categories, or there are two categories of marks in the Lanham Act that are not subject to registration. One is a disparaging mark, disparaging of a group of people, and the other is a vulgar mark, or a salacious mark. And so, for example, the mark that has gone up and down and up and down and up and down is the Redskins, with the allegation that the term Redskins, even though associated with football, is a mark that is pejorative to Native Americans. Lately, that case went to the Supreme Court with a different mark, and that went with the mark the Slants, brought by an Asian rock group who was trying to call attention to the use of the term, and the Trademark Office refused to register the mark the Slants under the statute, claiming that it was a disparaging mark. And the Supreme Court of the United States upheld the Federal Circuit, I believe it was the Federal Circuit, and declared that the Trademark Office's enforcement of this prohibition, this ban on registration, was a violation of free speech rights. That these are expressive marks, could be expressive marks, and that the Trademark Office was opining as to what is and what is not, and therefore that was not proper. Around the same time, another mark was going through the courts, and this mark involved a case called Brunetti. And the word was fucked, F-U-C-T, and it was applied to t-shirts. The Federal Circuit looked at the Tam decision and said, we don't know why Brunetti, fucked, would not be subject to the exact same rules that the Slants would be subject to. And there was some relative agreement with the Trademark Office that, yes, that's the case, with a letter sent to the court. However, they reserve the right to appeal, and the Federal Circuit declared that the section of the Lanham Act that dealt with vulgar marks, indecent marks, was also unconstitutional. And however, in September of this year, 2018, the Trademark Office asked the Supreme Court to grant cert and to hear Brunetti fucked. I don't think they're going to hear it. It's hard to predict. It's not a good idea to predict on film what's going to happen. But I don't think they're going to hear it. I think they're going to allow it to achieve basically the same result as the Slants. Vulgar, disparaging, there's really not a lot of difference, but the Trademark Office wants to know, and it has the right to know, and that's where that stands. So right now, our understanding in talking to the Trademark Office and a judge of the Trademark Office is that the disparaging marks are going through, the vulgar, indecent marks are being held in abeyance. And let me just add, there were a lot of marks that were vulgar that had in fact been registered by the Trademark Office prior to Brunetti, because those marks were really double entendres. And the Trademark Office would look at those and they would say, well, but it could mean this, or it could mean this. And then, quite frankly, one of the problems in all of these cases is the arbitrary nature of how the examiners deal with this, because you have many, many lawyers who are examiners in the Trademark Office, and one lawyer may consider a mark to be vulgar, and another trademark examiner may consider the mark not to be vulgar and let it through. So I think the Supreme Court is going to adopt the same rules.
Okay. So for the marks that fall in the disparagement category, there is no more prohibition under the Lanham Act that those marks can't be registered. So you can now apply for and register a disparaging mark.
That is correct.
Right.
Yes.
And so those marks get to enjoy the same benefits that all the other federal registrants have, whereas before they could only enjoy common law rights.
Yes, they enjoy the same benefits, but they also are subject to the same rules. So they can't be merely descriptive, they have to be descriptive with secondary meaning, or they have to be suggestive or arbitrary or fanciful in order to get registration. You'd have to register them under an ITU or a use in commerce. So it's all the same rules, but the prohibition, the ban, is now out the window. Unless, of course, Congress comes back and tries to resurrect it in some fashion.
Okay. And when do you think we may hear whether or not the Supreme Court is going to hear the case with the vulgar marks?
I think clearly we're going to hear that by March of 2019. We'll see whether they're going to grant cert. And if they do, I assume that the arguments may occur and the briefing may occur in 2019.
Okay.
I'm Jim Astrachan.
And I'm Donna Thomas.
And we're from Astrachan, Gunst, and Thomas in Baltimore. Our website is agtlawyers.com.